Good afternoon. This is Don Green. Many of you know me from the gun shows, my website, and you know us from the American Guns and Glory Network. And you know that we've been producing and directing a number of shows over the past couple of years, especially to focus the listening and video audience as to particular issues which have come up as a result of either the COVID-19 pandemic or other matters which are going on right now involving shootings and really extraordinary trials. Today, we're going to present something a little different. And this is for all concealed carry permittees and all people who want to consider having a firearm and all those people who are open carrying, which you shouldn't be doing. But we're going to focus your attention on what happens during a shooting and the aftermath in court. And we're going to be presenting some real-world examples today to focus your attention on reactions, what juries like to see, and what although every case is different and every person is different in their reactions, these are classic examples right now within the past 30 days that you should be aware of. May we have slide number 1.
And there were three people right there.
Take a deep breath, Kyle.
That's what I... That's what I run.
We're going to just take time for our break anyway. You can just relax for a minute, sir. We're going to take a break about 10 minutes, and please don't talk about the case during the break. Read, watch, or listen to any account of the trial.
Ladies and gentlemen, that is an excerpt from the trial of Wisconsin versus Kyle Rittenhouse. He was found not guilty in November 2021. No one is condoning shooting anyone. But when you do, and you're arrested, and you're charged with a crime, or you're charged civilly in a lawsuit, we'll discuss that a little bit later, you have to be able to articulate what was going on in your mind at the moment of the shooting. Under Nevada law, for example, and under California law, the self-defense is focused on that moment. Not what happened 2 days before, not what happened the week after, but in that moment and the few moments afterwards. What's significant about Kyle Rittenhouse? There's no question that 2 people were killed and several other people were injured. But his defense was one of self-defense. Even though he brought the firearm to the scene, which was perfectly legal, although there was some contention as to whether or not this young man, then 17, could have even had that firearm. But he was found not guilty. Why? In the excerpt, you see Rittenhouse crying as he's articulating the moment that he's shooting someone, that someone is being shot, not for the purpose of killing, but as you'll find out in a few moments, the reason why was to stop the threat to him at that moment, and he perceived a situation involving great bodily injury or death to him at that moment. That is the law of the state of Nevada. That is the law in California. And you see that he is being emotional. Some commentators in the media said it was fabricated. Others were defending him. But if you look at something, when he was first interviewed at the police station, he's crying on his mother's shoulder because someone is dead and he is the one who's being accused. May we have slide number 2, please?
Good morning, Mr. Rittenhouse.
Good morning.
Everybody that you shot at that night, you intended to kill, correct?
I didn't intend to kill them. I intended to stop the people who were attacking me.
By killing them.
I did what I had to do to stop the person who was attacking me.
By killing them.
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force
I used deadly force.
that you knew was going to kill.
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
You intentionally used deadly force against Joseph Rosenbaum, correct?
Yes.
You intentionally used deadly force against the man who came and tried to kick you in the face,
Yes.
correct? You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
Since August 25th, 2020, this is the first time that you have told your story.
Sustained.
Since August 25th, 2020, you've had the benefit of watching countless videos of your actions that night, correct?
I've seen certain videos, not all of them. I've seen the majority of them actually here during the trial.
You've also had the opportunity to read articles. People have written interviews, things like that, about what happened that night, correct?
I do my best to avoid what people write on the internet. A majority of it's not true.
You have also sat here through 8 days of trial, correct?
Yes.
And you've had the opportunity to watch all of the videos that have been
Yes.
played in this trial.
Yes.
Sir, if you could please let me finish my question before answering. And I will do my best to let you finish your answer before I go on to the next question. Fair?
Yes.
You have also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I'm going to ask you folks to go in the library for just a second. Please don't talk about.
We see now a dramatic difference between the direct examination of Kyle Rittenhouse and now the cross-examination by the prosecution. The reactions of defendants in many of my cases, and I've had over 75 jury trials, but dozens and dozens of pretrial proceedings involving where people do testify. We see that the prosecution was trying to get him to admit, did you intentionally kill somebody? Yes. Did you do this in a particular fashion? Yes. And when he was coming at you, was your intent to kill him? Answer, no. Rittenhouse answered correctly. I was addressing the threat. Now, I always advise people to continue their training, regardless of what training you get at a concealed weapon course. It is not enough. Because one of the first questions I'm going to ask you, and what I asked recently of a client, is what training have you had in addition to your CCW before today? Answer, I went to this course, or I didn't go to any other course. Because if you go to other courses, it appears as if you are being responsible. But getting back to Rittenhouse, you notice, was he calm, cool, and collected? Well, he wasn't being asked questions to invoke emotion. He was asked very straightforward questions. Some of them ultimately were ruled by the judge to be improper, but we're not arguing that. What we're arguing here today is that they were yes or no questions so that the prosecution could lock Rittenhouse into those answers, yes or no, and not allow him to explain anything. Contrast that with his earlier direct examination where he was allowed by his attorneys to articulate the movements that he was making with the weapon, who was going to kick him in the face, who was showing another firearm, displaying the firearm as he was laying down, and he shot one of those other people. Unfortunately, the person did not die. But if we notice the prosecution, again, yes or no to prevent Rittenhouse from answering the question in any way other than what the prosecution sought to receive the answer. Now, there were some objections sustained by the judge, but again, we're not here to argue those. We're not here to go through those particular objections, only to show that as a person who is involved in a shooting, you need to be prepared. And the way you're going to be prepared is continuous training and learning. You can learn from videos. You can learn from Court TV. And there's also the best training is to go to advanced classes where they're going to teach you of different scenarios. Perhaps there may even be shooting scenarios in simulated homes or outside, because the probability is the shooting is going to occur outside or it's going to be inside, of course. But where will it be? In front of Walmart? In the desert? At the movie theater? Because remember, the movie theater case is coming up, I think, in February or March, and that's where the gentlemen were fighting over popcorn at the seat, and the man with a concealed weapon permit, a retired law enforcement officer, shot a man in the theater for an argument. It wasn't worth it, but the problem here is he can't articulate, and how he articulated in the pretrial interviews was, I don't think he was prepared by his lawyers, because his answers were very perfunctory. Oh, I shot him because he threw popcorn at me and he slapped my face. You know, you can always walk away. But contrast that with Rittenhouse, who one of the people actually had a firearm pointed at Rittenhouse's head. Someone beat him about the body with a skateboard, so he shot back. Again, highly unusual circumstances, but the moral of the story is you have to be prepared. May we have the next video?
What were you thinking at that moment?
I was thinking of my son. It sounds weird, but that was the first thing that hit me.
What did you do?
I shot.
Why?
He had my gun. He struck me. It was obvious that he was. It was obvious that he was attacking me. That if he would have got the shotgun from me, then it was this is a life or death situation, and I'm going to have to stop him from doing this. So I shot.
Did he stop when you shot?
He did not. No, he did not.
That's an excerpt from the direct examination of Mr. McMichael, one of the three men in the Ahmaud Arbery case there in Georgia. We're holding the video here to point out a key fact. Mr. McMichael says it's a life and death situation. But notice how he articulated it. He did look down once, but he came back up. We're not asking anybody to fake it. But when he said it was a life or death situation, with all due respect, it appeared to be an interview for a job as a manager at Walmart. It was too rehearsed, and there was no emotion, because he needed to show it was my life or his at that moment, sir. And so he grabbed the gun, and I got it back away from him, as opposed to it was a life or death situation. He grabbed the gun, and I thought he could use it on me. Let's continue with the video.
So what I'm going to do now is talk about what happened on the 23rd of February, okay, of 2020.
Yes, ma'am.
All right. So let's go ahead and start at the moment your dad kind of came running into the house. He was yelling for you, correct?
Yes, ma'am.
All right. He yelled that the guy from the other night was running down the road.
Yes.
And you understood that he was talking about the black van that you had seen go into the open unsecured construction site 12 days beforehand on February 11th.
He said the guy that had been breaking into the house just ran by. So yes, that was what I was thinking at the time.
And your father ran into his bedroom to get his .357 Magnum revolver.
Yes, where it was, yes, ma'am.
Right. And I want to be real clear. He didn't say he'd seen the man breaking into the house,
No,
just that he'd seen the man running down the street.
that has been breaking in the house, is what he said, yes, ma'am.
And you hadn't seen the black man in the 12 days between February 11th and February 23rd, had you?
I did not.
And at this time, you were working at Metson Marine,
I was.
and your hours were really early in the morning to about 5 at night?
It depended on what was going on. It was usually 5 to 1 or 2 in the evening, but it could change so much.
All right, so I just want to be clear. 5 o'clock in the morning to 1 or 2 in the afternoon, or are you talking 5 p.m. to 1 or 2 at
5
midnight?
a.m. to 1 p.m. sometimes.
All right, so on February 23rd, 2020, when your dad came in and yelled for you, you didn't know where the black man was coming from.
I had an idea because he said he running down the road, the guy's been breaking in. I've never seen him before. I've kind of had an idea that maybe he's coming from 220. But we'll just go out and check out and see what's going on.
But your dad just said he's running down the road, correct?
Yes,
And you didn't know where he was going when he was running down the road.
I did not.
All right. And you had no idea what he'd actually been doing that day.
Not at that time, no.
But what you did know at that point in time was that Mr. Arbery had been at the open unsecured construction site on February 11th. Is that right?
Yes,
And you knew about 2 other times, is that correct?
I knew that he's been there several times, 2 other times, and that stuff has been stolen out of there. And then the way that he reacted to me on the 11th was the thought that was in my mind.
All right. Now, you didn't suspect him of having stolen your handgun out of your car 54 days earlier, did you?
No, I have no idea who did that.
Did you tell Diego Perez that you knew who did it?
No, I didn't.
Did you indicate to Diego Perez you had a good idea who was a good suspect in the neighborhood who had done it?
To Diego? No, I did not.
Did Diego Perez actually show you the videos from his house to see if anyone was going up and down, cars or people?
On the first,
When
when my
you-
pistol
yes.
was stolen. So I walked around, I started noticing that everybody had these things, so I saw that Diego's house had cameras while I was waiting on the police to come to make the report. That's the first day I met Diego. And I asked him if there was any, if he had any footage from this morning, because I had a pistol stolen. And I asked if I can have his thumb drive. And I got his thumb drive and looked through, and I didn't see anybody. Saw a couple of trucks that were, I've never seen before, that had me wonder a little bit, but I didn't see anybody on there.
We are now seeing 2 different types of cross-examination. You saw the precise questions being asked by the prosecutor in Kyle Rittenhouse, yes, no answers. Contrast that with the prosecutor in Georgia. Very deliberate questions which allowed Mr. McMichael to articulate what was going on. But look, notice her questioning. Her questioning was designed to elicit answers of matter-of-fact things, other than it was my life or his. But you notice how she stayed away from that very carefully, very cautiously. Of course, there was the hours of the direct and cross-examination. So we're only talking about little snippets right here. The lesson to be learned here is preparation. Mr. McMichael mentioned 2 important points. And, well, I was walking around. Then could he have called 911 or called the non-emergency? We might have a break-in in this area. Rather than the vehicle pursuing this suspect, that leads to this Georgia law for citizen's arrest. But in the best CCW classes offered in Clark County, and the limited ones which are offered in California, the good ones are always going to tell you that you do not pursue the suspect. Once you pursue the suspect, you become the suspect unless the suspect turns around and comes at you, so that you, although you were the initial aggressor in Nevada, you can use self-defense so long as you try to disengage. Not required from the plain self-defense when someone's threatening you. What I just mentioned about pursuing or becoming the initial aggressor is only after, when you're the first guy to start the fight and the guy comes at you, you've got to try to back up. And if you don't back up and you don't articulate that, you're going to be charged with murder or manslaughter. Now remember, the defenses in McMichael were basically two. Citizen's arrest, which was somewhat suspect, and then it becomes self-defense. As you saw Mr. McMichael talk, his rather matter-of-fact tone, but maybe that's his style. But remember, he had also given a statement almost immediately after this incident occurred. And his statement at the scene was more, well, like, I had to shoot him, he was going to shoot me, or he was going to grab the gun, but still, it was matter of fact. It wasn't as if he was showing that he had just killed somebody and was remorseful. And he did not see the felony. We're going to take a short commercial break here, and we'll be back in a few minutes. Thank you.
Freestyle Martial Arts, located at Jones and Russell here in Las Vegas. You can reach them at 702-551-9009. That's 702-551-9009. CCS Gunsmithing. Chris Eifelt, the man who does all the NRA help, he's at 2216 South Rainbow Boulevard near Sahara. He can be reached at 702-365-1732. Once again, 702-365-1732. CCW Maggie is found all over the internet. You can reach her by phone at 702-375-5900. That's 702-375-5900. All sorts of firearms training, ladies only classes. She is the best of the best. Call CCW Maggie. Attorney Donald J. Green, a common guest of mine on Fired Up. He can be reached at 702-409-8239. He specializes in gun case litigation. He is your man. Don Green, 702-409-8239. And Battlefield Vegas, my new kind of home for this show. They're on Circus Drive, directly behind the Circus Hotel and Casino. You can find them there with CCW classes and an amazing place for gun rentals, everything you could possibly imagine. Check out, if you're in town as a tourist, check out battlefieldvegas.com.
Welcome back to our special program. My name is Don Green. We're bringing you a special broadcast today. We just finished the first part of it to present timely issues, especially for our Nevada audience. And please remember that last year, the Nevada legislature, which only meets every odd year, had some bills proposed for the storage of firearms. And Nevada, right now, if the firearms are not stored properly, it's a misdemeanor. I have a feeling after the next legislative session in the next couple of years that it'll probably be a felony if something happens, or a child or a person unauthorized to use the firearms has access to those firearms and they're used in some type of a crime. Case in point. We've recently had a shooting in Michigan. Very tragic shooting. 4 people at a school shot, others injured. But for our audience, it's not so much the focus on the young man, 16, 17, 18 years old, however old he was, not focusing on him, but on the parents. May we have slide number 5, please. In Nevada, again, we have a new law which strengthens existing statutes relating to the storage of firearms. And as of January 1st, 2020, it will be a misdemeanor to negligently store or leave a gun in a location where there is a substantial risk that a child should be prohibited from handling or possessing a firearm or may gain access to it. I think that's going to change to child or prohibited person or other persons like if you've got an uncle who's incompetent, who's got some mental issues. But what we have here, it's very timely, is we have parents charged in Michigan now with several counts of involuntary manslaughter. Slide number 6, please. We'll get to that. But before we do, we need to advise everybody, very importantly, about alcohol use and gun possession. Our new statute lowers the alcohol level for a concentration of a person possessing the firearm from 0.10 to 0.08, which is equal to the DUI statute. And possession of a gun while being under the influence of alcohol or a controlled substance, it remains a misdemeanor, but it's going to be more serious because I have a case right now where a person has a concealed weapon permit but was drinking in a bar, is now charged with a felony possession of the firearm even though he has a concealed weapon permit. Why? Because he's got a very high blood alcohol content, and that diffuses and that neutralizes any defense of the, I had a concealed weapon permit, so I had to use my weapon. That's not going to be the case anymore if you're under the influence of alcohol, and it better not be marijuana, because remember, under federal law, marijuana is still a felony and a controlled substance. Can we have slide number 7, please? Getting back to the Michigan case. Again, the parents were interviewed a day or two after the arrest of the suspect. And when they were interviewed, and they said stuff on a video, apparently some kind of a video conference where they were setting bail. And I believe, and it could stand corrected, that the prosecution at the time of the bail setting had mentioned something that others were still being investigated for possible criminal culpability. At that time, the attorneys for the husband and the wife should have shut their mouths, told them to keep quiet. Why? Because, as I predicted, the parents were going to be charged because there were YouTube presentations or Instagram or Twitter references showing that this 17, 18-year-old kid had the weapon. It was a birthday present or a Christmas present or something, and they let him have it. And there were some problems with the school. When the kid went to school, within days or hours before this even happened. Here's what happens to the parents. Slide number 8, please. The parents are apprehended in a warehouse. Allegedly, they were on the lam, they were on the run. According to their attorney, they were only leaving the jurisdiction because of death threats, perceivable, real death threats against them. So, somehow or another, they left. That's the argument of the prosecution. But now, there's a combined bail of $1 million. Why? The prosecution is saying that the parents were responsible and that firearm and bought the firearm. And they keep harping on the fact of these types of firearms, the Sig Sauer and the other weapon. And they're presenting evidence at the bail hearing that the parents may have facilitated this in some way, that it's a Christmas present, it's a birthday present, but the focus here is don't give the kids a firearm if you believe that there's something wrong with your child. And what happens? The parents are charged, not with, some little child abuse and neglect that's probably going to get negotiated. They're charged with involuntary manslaughter. Of the 4 people who were shot at that school, combined bail, $1 million. I'm not sure exactly what the split is, but that is an incredibly high bail. Probably will not be made by the parents, probably not going to be lowered because of the political climate, political correctness, and the nature of the crime. What happens now? May we have slide number 9. Within the past 48 hours, and this is incredible, a massive lawsuit was filed in the state of Michigan. The lawsuit is in front of you right now. It's a lawsuit which is seeking $100 million in damages filed against the Oxford School and district officials. The parents are not yet named, they might be, but the school is probably going to name them as third-party defendants, although they don't have any money, or probably not enough to pay the judgment. And they might not be able to file bankruptcy to prevent the judgment in the event they're released from custody, because the bankruptcy laws prevent you from getting a discharge for intentional torts or acts. Now, we're not sure if this is going to happen, but for our people in Nevada, especially with our new statute, you have to be aware that not only are there new criminal penalties because of the law which became effective in January of 2020, but now we've got what I consider to be one of the first most immediate lawsuits involving these particular types of mass shootings in schools. There have been other lawsuits, but I don't remember one being this quick. I believe that the shooting only occurred the last couple of days of November. And here it is in December. The lawsuit's filed, I believe, on the 9th, just day before yesterday. What do? If you have young children or incompetence in your house, or you've got, a senile grandfather or uncle, someone who should not have a firearm, a drug-addicted daughter or son or brother-in-law, you need to, number one, determine if that is a safe place for them or get them another house or apartment. Your children, of course, it's a different story. But you need to go and buy the best safe which you can afford. I'm not talking about going to buy those safes on sale for $39.99 at some big box stores. I'm talking about getting a safe that's going to probably set you back between $500 and a couple $1,000s. Why? Because it's going to cost you an enormous amount of money for a private lawyer to defend you in a possible civil and a possible criminal case of something which could have been avoided with proper assessment of your situation. And that is, get the safe. And don't leave it in the living room. Don't open it up to show your friends, because you don't know who they are. Do you know their backgrounds? And I've had dozens of situations where the police have gone to knock on the door looking for a felon who happened to be the brother-in-law or the brother or the son. The police ask if there are any weapons in there, and there's weapons right there laying on next to the bed or on the nightstand, and in some cases in a gun shelf. A lot of you people might not remember Sears and Roebuck, but it was one of those wooden gun shelves with glass doors right next to the front door. And my client was a senior, and his son-in-law had come from back east, and it was living with them, was a registered sex offender, was a felon, and did not register. And that's why the police and the probation authorities ended up at the house. They asked him, Does this person live here? Yes, he does. And they could see the weapons in plain view. You shouldn't use those anymore. Not in today's world. Maybe if you've got a $1 million mansion somewhere and you've got gated security and armed guards walking around, then keep it in the shelf. But not in the modest home. Not in your apartment. Not in your trailer. Not in your townhome. And certainly not in your office. So when you look at this lawsuit, and if we could talk about the damages, if we could look at slide number 9 again. The lawsuit is seeking, damages for emotional distress, for intentional acts, and they're asking for $100 million. And the school district, even if they try to settle out, it's going to be a hard time. Maybe this case was just filed just to get people to get money. Maybe they didn't really care about their children, and now they're going to be instant millionaires without having to win the lottery. But they're going to have to live with this judgment, especially these parents, because the school district is going to sue everybody they can, including the firearms manufacturers. They may even sue the gun store, because when the parents filled out the form, and I saw this constantly referred to by the prosecutor in that county in Michigan, she constantly referred to the ATF forms. And one of those, we have the book here for the ATF, one of those forms, and I brought the regulations, one of those forms is for a lower receiver. So, yes, you can buy the lower receiver. That's the part which gets put on, registered on the 4473, the ATF form. That's what's put on there. And people say, oh, there's no official record of gun sales. Yes, there is. Because every firearm sold in the United States through a gun dealer and now through private sales in Nevada must fill out the form 4473, and it's got the type of weapon, the name, the caliber, the serial number, and the federal firearms licensee must keep that form in its entirety for 20 years. Not download it. Yeah, maybe they can download it and put it on a flash drive, but they have to keep the actual form for 20 years. That's the law. So I have a feeling that if the parents did buy the weapon, and it's on the form 4473, and where it says, are you the actual transferor? And they're admitting on the TV or YouTube or Instagram, we bought it for our son, that is a federal offense. Title 18 of the United States Code, Section 1001, false statement to federal officers or false statement in connection with official federal duties. So I see that happening because they blurted out, we bought it. And I'm going to tell you right now, I've had 50 cases over the years, and I've been a lawyer almost 40 years, where the people have said, I'm buying this gun for my son, I'm buying it for my husband. Now, even though you can buy the weapon and later transfer it to the relative without a background check, and you can do that under the new background check law, you can't transfer it to your brother-in-law, you can't transfer it to your sister-in-law, you can transfer it to your brother or your adopted sister. Why the difference? Because the Nevada revised statute and the legislature says, no brother-in-law, can't transfer it to them. You have to take it down to the dealer and the FFL dealer and do a background check. And if you don't, it's a crime. And there are sales going on right now. There are sales going on yesterday between private individuals, and they're saying, oh, I didn't know that was the law. Ignorance of the law is no excuse. Now, where do I find out about this? You find out through training. You find out through going online. And not just the blogs that talk about the Second Amendment. You need to go online to perhaps NRA, if they're still using it, although they're in bankruptcy. But there are some very good online sources. Go look at the news that's put on by AmmoLand. Go put on the news that might be put on by Gunbroker. And of course, go look at the updates from the Bureau of Alcohol, Tobacco, and Firearms. Now, a lot of people say, well, I don't really want to know. They want to know that I'm looking at them. In my experience, the agents and the people working for the Bureau of Alcohol, Tobacco, and Firearms are very knowledgeable and very helpful. And they do want to help you. The problem becomes when you have a situation such as the parents in the Michigan shooting, as far as this portion of the show is concerned. So here's what you do. Training. Make sure that you know what you have in your home. The best safe which you can afford. Whether you have children or not, you should have a safe. Keep an inventory of your weapons. Know what serial numbers are yours. Keep the ammunition away. Don't leave the firearms out, except if you're home or at night, and certainly not where children can get to them or incompetence. And again, I think the law is going to change to add incompetence or otherwise prohibited persons, felons, registered sex offenders, people who've got battery, domestic violence, people who've renounced their citizenship, people, and here's one that's becoming very popular, people who have not received honorable discharges from the military. You need to check into that because some of the people are getting general discharges or discharge in lieu of court-martial or discharges under less than honorable conditions. You need to check on that because the ATF and I think the FBI is going to start interpreting that as a prohibiting factor. So make sure that you know this. And this is part of responsible gun ownership. This is not gun control by the government. This is common sense to prevent tragedies from happening like in Michigan. And you're always welcome to call me. You'll see the screamer going across occasionally. And my cellular phone, 702-409-8239. Attorney Don Green. I'm licensed in California and Nevada with the substantial emphasis of my practice being on firearms. Here's a quick commercial. This coming weekend on the 18th and 19th of December here in Las Vegas, there'll be a gun show at Alexis Park put on by Western Trails. The Alexis Park facility is a great facility. I expect that there'll be a lot of people. Get there early, park, take an Uber, whatever. And also, make sure, double check your concealed weapon permit. In the last several gun shows and in several phone calls in the past several weeks, I've had people who are coming up on expiration of their concealed weapon permit and actually ones which actually had expired. I was at a gun show in late August, early September, and the guy was talking about it, and I said, well, when does your CCW expire? He looked at it and says, oh my God, it expired like in June or July. What do I do? You have to go and take the test and everything again. Nevada has no grace period. I don't care what they say on the internet. No grace period. So with that, I want to have everybody have a great day. You're always welcome to call me. I hope this program has been very informative. We'll see you the next show.